Case will now be heard on the 18th, 19th and 20th of January, with 7-judge bench at the appellate court issuing new timelines that have spelled doom for the BBI proponents. And as David Mudoka now reports, a do-or-die moment awaits the BBI process that has suffered 2 legal blows already, with its proponents seeking a much-needed reprieve.
BBI proponents and opponents have just 2 months to brace for one last dance, this time at the Supreme Court, which on Tuesday set aside January 18th, 19th and 20th, 2022 to hear the BBI consolidated petitions.
This is the application for the recusal of 2.
And besides setting the hearing dates, the Apex Court judges further dismissed an application by lawyer Isaac Aluochier to have 3 Supreme Court judges, Mohamed Ibrahim, Njoki Ndungu and Smoky Wanjala, recused themselves from the case, accusing them of being biased. According to the Supreme Court bench, the petition was an afterthought, ill-conceived and meant to delay the petition.
The applicant has not demonstrated and or adduced any such evidence in support of the allegations on bias by any of the cited judges. C, the application is self-defeating for the reason that whereas the applicant cites 3 judges for recusal, it seeks the recusal of only 2 of them.
This as the judges issued deadlines for the filing of submissions by the appellants and respondents, who are now in a race against time. The appellants will have 15 days now to file written submissions. The respondents will have the same number of days to respond, while the appellants will have a further 5 days to reply if they wish so.
Parties will be given 28 pages for the written submissions. And that will also mean that during the hearing, parties will be given 20 minutes to highlight the submissions.
But while the parties adjust to the new dates, the time is ticking for BBI proponents and their hopes for a pre-election referendum. With the hearing coming barely 7 months to the August 2022 contest, the judgment could come just 4 months to the election if the 2-month period that the appellate court judges took to write their verdicts is anything to go by. It is unlikely that a country on the verge of changing guard will be in any referendum mode. Further, some BBI proposals, such as the recommendation for a new IEBC, are already behind schedule, spelling more doom to referendum plans. But while the BBI finale looms, the appellants, among them Attorney General Paul Kihara Kariuki, the BBI Secretariat and the IEBC, will be seeking to be that time lucky and have the Supreme Court amplify the volume of the BBI reggae rather than ultimately mute it. 7 concerns are expected to form the bulk of the BBI petition, among them whether the president is supposed to initiate a constitutional change, whether the president can be sued in the course of his tenure for something done or not done, whether the IEBC met or lacked quorum during the initial referendum stages, as well as whether the basic structure doctrine is applicable in Kenya, and if so, the extent of its application. David Mudoka, TV 47, Nairobi.